Good morning, we are on the record. This is Judge Elaine Barber. We're here for initial appearances. Appearances, please.
Abraham
Callie
Elmazahi.
Chrysler, Assistant.
All right, state,
Abraham Elmazahi on behalf of the state of Florida.
defense.
Callie Chrysler, Assistant Public Defender out in Osceola County.
PTR.
John Marino, PTR.
All right,
Theodore Leal, Spanish interpreter.
thank you. Has the interpreter been previously sworn?
No, Your Honor, interpreter has not been sworn yet.
I'm sorry, I couldn't understand you.
The interpreter has not been sworn yet.
Please raise your right hand to be sworn.
Yes.
Do you solemnly swear or affirm that you will truthfully translate from English to Spanish and Spanish to English all of the testimony and questions asked?
Yes, I do. Theodore Leal, certified Spanish court interpreter.
All right, so who do we have down there that needs a Spanish interpreter?
We have Javier Perez Moya.
All right, hold on. We'll take him first. Javier Perez Moya.
And I believe he would like to have the reading of his charges waived, Your Honor.
Okay.
Javier?
Come on up, sir.
Acérquese, señor.
Sir, tell me your name.
Señor, dígame su nombre.
Javier Pérez.
Javier Pérez.
Sir, I've reviewed a probable cause charging affidavit that charges you with a felony of the 3rd degree and it charges you with a misdemeanor of the 1st degree. I do find probable cause for each.
Señor, acabo de leer el documento o juramento en el cual se denota que hay un delito de 13 grado, al igual que un delito menor de primer grado y que hay indicios de culpas.
And does he qualify for the services of a court-appointed attorney?
Yes, Your Honor.
All right, I will appoint the
Sí.
Office of the Public Defender to represent you.
Y sí voy a designar, ya que califica a la Defensoría Pública para que lo represente.
All right, PTR, the face sheet indicates that he is out on felony probation in 2017 CF 4052 at the time of the offense.
Al momento del delito,
Yes, Your
el
Honor.
caso 17 CF 40052, él estaba bajo libertad provisional por un delito cometido. Y sus
All right, and
And he
that,
is also on 19. He is also on for 19 MM 890 for petty
también por el
theft.
caso-
That was on 830.
también por el caso de un delito menor, de un hurto menor, en el caso 19 MM 890.
all right, so he was sentenced on August the 30th and placed on probation in that case? Is that what you're saying?
Yes, Your Honor.
Estaba entonces bajo prueba por el caso de agosto 30. Sí, su señoría.
All right. All right, sir, I will find an on-view violation in 2019 MM 890 as well as 2017 CF 4052.
Entonces, señor, voy a determinar que usted sí ha cometido una violación a su régimen en el caso 19 MM 890 y en el caso 17 CF 4052.
You'll be held without bond on those two cases pending further order of the court.
Entonces queda hasta nuevo aviso del tribunal, usted queda sin fianza por esos cargos.
With regard to count 1 in the new law affidavit,
En el cargo número 1, en el nuevo affidavit,
I will set bond in that case in the sum of $3,500 as to count 1, $500 as to count 2.
iban a ser $3,500 en el cargo número 1 y $500 en el cargo 2 por el nuevo caso de la nueva infracción.
Special conditions of your release will be that you not return to the scene of the offense,
Como condición de liberación, usted no podrá volver al lugar de los hechos,
maintain separate residences,
mantener residencias separadas,
have no contact with the victim in the matter,
no tener ningún contacto con la víctima en este asunto,
do not come within 500 feet of her place of employment,
no acercarse ni a 500 pies del lugar de donde ella trabaja,
not be in possession of any firearms or any weapons,
no tener en su poder ningún arma de fuego.
and that will be all, sir.
Eso será todo, señor.
Thank you.
Gracias.
And then we have Jose Sanchez Roman.
Tell me your name.
Dígame su nombre.
José Luis Sánchez Román.
José Luis Sánchez Román.
All right, sir, I've reviewed a probable cause charging affidavit. It charges you with DUI.
Señor, ya revisé el affidavit de acusación por conducir bajo los efectos.
Second offense
Segundo delito.
charges you with driving on a suspended license.
También lo acusa de manejar con licencia suspendida.
And it charges you with refusal to submit.
Y también lo acusa de rehusarse a someterse a un examen
To a blood alcohol test.
para el examen de nivel de alcohol en la sangre.
I do find probable cause.
Determino que hay indicios de culpa.
As to count one, bond will remain at 1,000.
La fianza queda en $1,000 por el cargo número 1.
As to count two, it will remain at 500.
$500 se queda así para el cargo número 2.
As to count three, it will remain at 500.
En cuanto al cargo número 3, permanecerá en $500.
At the time of your arrest, sir, you were out on bond
Usted estaba bajo fianza en el momento en que lo arrestaron
and pretrial release.
y bajo libertad provisional.
You were out on pretrial release in 2019 CT 2693.
En el caso 19 CT 2093 estaba bajo libertad provisional
For the offense of DUI,
por el delito de conducir bajo los efectos.
and you were out on bond in 2019 CF 2783.
Y estaba bajo fianza en el caso 2019 CF 2783.
I do find probable cause for a violation of your conditions of pretrial release, and I am going to revoke your bond.
Entonces veo que sí está en violación en las condiciones de libertad provisional y le voy a revocar la fianza
And release status in each case
y el estatus de liberación en cada caso.
holds you without bond in those matters.
Y en esos asuntos queda sin ninguna fianza.
Does he qualify for the services of a court-appointed attorney?
Yes, Your Honor.
No sé si califica para un defensor público.
I do appoint the office of the public defender to represent you.
Designo una oficina de la Defensoría Pública para que lo represente.
Thank you, sir.
Gracias, señor.
Do we have anyone else that needs the services of a Spanish interpreter?
¿Hay alguien más que necesita los
Spanish,
servicios del
no.
intérprete?
Okay, so we do have,
Spanish, no, Your Honor.
all
We
right,
do have a Creole interpreter that's needed.
all right, we'll take him last, okay?
Yes, Your Honor.
Next up, I have Luis Banero. Tell me your name, sir.
¿Su nombre, señor?
I'm sorry, Mr. Interpreter, we do not need you
I don't
for
need
any
an
other
interpreter.
Spanish cases.
Can the interpreter be excused, Your Honor?
You may.
Thank you, Your Honor.
Well, Mr. Interpreter,
Yes, Your Honor.
we do need you to stand by for Orange County. We don't need you for Osceolas, but we do need you to stand by for Orange, okay?
Very well understood, Your Honor.
All right, thank you.
You're welcome.
All right, sir, again, tell me your name.
Luis Bonanno.
All right, sir, I reviewed a probable cause charging affidavit. It charges you with battery and resisting an officer without violence. I do find probable cause. Does he qualify for the services of a court-appointed attorney?
Yes, Your Honor.
I will appoint the office of the public defender to represent you, sir. I will, in count one, set bond in the sum of $500. As to count two, in the sum of $500, that's a total of $1,000. Conditions of your release will be that you not return. You have no contact with your sister, who is the named victim, and that you not be in possession of any alcohol, you not consume any alcohol, you not visit places whose primary source of revenue is from the sale of alcoholic beverages, you not be in possession of any weapons or any firearms. I note that the victim wants contact, but I am denying contact. According to what I'm looking at with regard to the information from pretrial release, you are currently on felony probation. in 2019 CF 4214. Is that correct, PTR?
Yes, Your Honor.
All right, so I am going to find a violation of your probation in that case, hold you without bond in that matter pending further order of the court to which it's assigned. Thank you. Elisa Brown? Good morning, ma'am. Ma'am, you're being held on an allegation of violation of probation or community control. Judge Tynan signed a warrant for your arrest. He did not grant bond in the matter. Bond will remain set at 0. I will appoint the Office of the Public Defender to represent you in this matter. Thank you. Stephen Chandra? Good morning, sir. You Stephen Chandra?
Yes, ma'am.
All right. Sir, I reviewed a probable cause charging affidavit charging you with battery on a person 65 years of age or older. I do find probable cause. Does he qualify for the services of a court-appointed attorney?
Your Honor, he has not yet filled out an affidavit. I had him as a reset on my notes, so I do not know. We would ask that you provisionally appoint so that I can get that filled out for him.
All right, I'll provisionally appoint the Office of the Public Defender to represent him. Sir, I am going to go ahead and grant bond in the matter with the following conditions. Bond will be set in the sum of $500. You are to have absolutely no contact with your father in this matter. There is a pending injunction, according to what I'm reading, with regard to your father issued in the state of New York. You are not to return to his address or come within 500 feet of his address, and that's 1320 Island Green Street in Kissimmee.
Your Honor, would you entertain a one-time return with law enforcement to retrieve personal belongings?
No. There is a active injunction out of the state of New York, so for that reason, I am not going to entertain a one-time assist. He wasn't supposed to be there in the first place if that injunction was active, okay?
Yes,
All right.
Your Honor.
Thank you. Carlos Corchado? Sir, tell me your name.
Carlos Corchado.
Alrighty. All right, sir, you're being held on an allegation of violation of probation or community control. It's in case number 18 CF 3083, signed by Judge Wooten. He did not grant bond in that matter. Bond will remain as set. I will appoint the Office of the Public Defender to represent you in the matter.
Thank you, Your Honor.
Thank you. Isaias Figueroa?
He is detoxing, Your Honor.
All right, we'll recall him
He is
tomorrow.
not here.
All right, he'll be recalled
Thank you.
tomorrow. Sinel Lebron Rosado?
Your Honor, and she would like to waive the reading of her charges.
Okay. Ma'am, you've been charged with a felony of the 3rd degree. I do find probable cause after reviewing the affidavit in this matter. Does she qualify?
Yes, Your Honor.
All right, I will appoint the Office of the Public Defender to represent you in this matter. I'll be heard on bond.
Yes, Your Honor. She does live in Florida, and she has for 3 years. She does have work as a paraprofessional, and she does have other children. And given the fact that with the impending hurricane and everything, that we ask that she be able to return home as well, Your Honor. She and her husband still have some work to do to prepare.
All right, ma'am, I'm going to release you on your own recognizance in this matter with the following understanding. You must keep the Office of the Public Defender as well as the clerk of the court apprised of all changes of address. The address that we have for you right now is 429 Mallard Lane, Kissimmee. Is that correct?
Correct, Your Honor.
All right.
Correct, Your Honor.
You are to have no hostile contact with the victim in this matter, and you are to obey all recommendations of the Department of Children and Family Services if they involve themselves, okay?
Okay.
All right, thank you. Christian Long.
Yes. Your Honor, he would also like to waive the reading of his charges.
All right. Mr. Long, I have reviewed a probable cause charging affidavit. It charges a felony of the second degree times 2, felony of the third degree times 2. I do find probable cause. Bond as to count 1 in, I guess you just need me to read the police case number here? All right, well, then I'll set bond the same, okay? As to each, it'll be $1,500 as to count 1. Bond will remain the same as to each at $500, so a total of $2,000 bond in each case. Conditions of your release will be that you have no contact whatsoever with the co-defendant in this matter, Gabriel Osa. You not return to the scenes of the offense, have no contact with the victims in the matter. All right, PTR, your face sheet indicates that he is out on bond in out-of-county cases, is that correct?
Yes, Your Honor.
All right, so I'll take no action on those. I will appoint, does he qualify for the services of a court-appointed attorney?
Yes, Your Honor.
All right, so I will appoint the Office of the Public Defender to represent you, sir. Also, conditions of your release are you are not to be in possession of any firearms or any weapons. You understand all that?
Yes, ma'am.
You understand the no contact with a co-defendant?
Yes, ma'am.
Thank you. Linda Nettinen?
She's approaching, Your Honor.
Okay. Ma'am, tell me your name.
Linda Netton.
All right, ma'am, I've reviewed a probable cause charging affidavit. It charges you with grand theft and resisting merchandise recovery. I do find probable cause. Does she qualify?
Yes, Your Honor, she does qualify, and as PTR has informed me, she has no history, so we would be asking for direct PTR in this case.
All right, I will appoint the Office of the Public Defender to represent you, ma'am. I am going to straight release you to pretrial release. Please make sure that your contact information, to include your address, is always kept updated with them, as well as the clerk of the court and the Office of the Public Defender.
Yes, ma'am. Thank you.
Thank you, Your Honor.
Thank you, Your Honor.
Gabriel Oso? Tell me your name, ma'am.
Gabrielle Oso.
Ma'am, I've reviewed 2 probable cause charging affidavits, each of which charge you with burglary of unoccupied conveyances or vehicles and grand theft third degree. I do find probable cause. As to count 1 of each, I will set bond in the sum of is that what I set on the other one? $1,500. $500 is to count 2 remains, so your bond in each is $2,000. I'm also going to require that you be released to pretrial release with the condition that you have no contact, so it's bond plus PTR. You have no contact with a co-defendant in the matter. You not return to the scenes of the offenses. You have no contact with the victims in the matter. And again, you not be in
Yes,
possession
Your
of
Honor.
any weapons or any firearms. Yes.
Your Honor, she also has no previous history. Would you please entertain direct PTR for her as well? She has no other previous criminal history.
She qualifies for the services of a court-appointed attorney?
Yes, Your Honor.
All right. Then I will straight release her to pretrial release. I'm also going to require, though, if I do that without monetary conditions, random year analyses.
Yes, Your Honor.
Thank you. Florencio Rios,
And
did you want to readdress something with her?
I was just going to clarify, still with no contact, no return, correct?
No contact, no return, no firearms,
Yes, Your Honor.
random year analyses,
Yes, Your Honor.
PTR.
Yes, Your Honor. Thank you.
Are you, what's your name, sir?
Florencio Rios.
Okay. All right, sir, I have reviewed a probable cause charging affidavit that charges you with possession of a controlled substance without a prescription and possession of drug paraphernalia. I do find probable cause. Does he qualify?
Yes, Your Honor.
I will appoint the Office of the Public Defender to represent you. As to count 1, bond will remain at 1,000. As to count 2, 500. Total bond of 1,500. Special conditions of your release will be that you obviously not be in possession of any controlled substances that are not legally and validly prescribed to you by a physician. Thank you. Jimeny Rodriguez. Mr. Rodriguez, I reviewed a probable cause charging affidavit that charges you with theft, and I do find probable cause. Does he qualify?
Yes, Your Honor.
I will appoint the Office of the Public Defender to represent you in this matter. With regard to this case, due to your prior history as well as the facts of the case, I am increasing bond in this matter to the sum of $2,500. Conditions of your release will be that you not return to any Walmart in the United States and you not be in possession of any weapons or any firearms. And I do appoint the Office of the Public Defender to represent you.
Thank you, Your Honor.
Jose Acosta Rodriguez. Sir, you're being held on 2 out-of-county warrants, one from Polk County where there is no bond, and another one out of St. Lucie County where there is a bond of $15,000. And are y'all being appointed by the IA judges, Madam Defense Attorney, with regard to transport at all?
No, ma'am, we have
Okay.
not been.
All right, thank you. All right, sir, so you will be detained until you are picked up from those counties and transported. Thank you, sir. Stephanie Forrest Hamilton. Good morning, ma'am. You're being detained on 2 warrants out of Orange County. One has bond set at 0. It is in 2018 CF 17540. In another case, you have bonds set at $5,000. That's in case number 2017 CF 4841. Bonds will remain as set. If the Office of the Public Defender has not been previously appointed to represent you, I do appoint the Office of the Public Defender to represent you in these matters. Thank you.
Thank you.
Yes, Your Honor. Your Honor, I think Mr. Jose Acosta might have gotten caught up into a Robert Calavito, because Robert Calavito has the St. Lucie warrant that I'm looking at right now.
Hang on one second. Who are you speaking of? What defendant?
It was the one previous to,
All right,
to the lady before.
you are correct.
And I have, okay.
You are very correct. All right, so where's Mr. Robert Calavito?
He's approaching, Your Honor.
All right, Mr. Calavito, it is you that has the St. County warrant, St. Lucie County warrant for $15,000, okay? All right, you will be picked up in that matter and brought over to St. Lucie County if you don't bond prior thereto, okay? Thank you. Recall Jose Acosta Rodriguez, please.
He's approaching.
All right, sir, just to clarify, you have only one outstanding warrant that you're being held on, and that is the warrant with no bond. And as I indicated, that is out of Polk County. Thank you, sir. Michael Joshua Ballou.
He's approaching.
Sir, Judge Tynan signed a warrant for your arrest for an allegation of violation of probation or community control. He did not grant bond. Bond will remain in the sum of 0, and I will appoint the Office of the Public Defender to represent you in the matter. Thank you. All right, so we have Renee Cardona. This is a reset from yesterday.
Yes, Your Honor.
All right, so on Mr. Cardona, yesterday I ROR'd him on count 1, stayed the bond in the remaining counts. There was an allegation that he was on probation in case number 2019 CF 1106, and I found a violation and held him without bond in that case. Is all that correct?
Yes, Your Honor.
All right, so why are we recalling it today?
I have in front of me, provided by PTR, a notification to release from the Department of Corrections that from the 28th of August, where it says, sending state is prohibited from retaking offender until pending charges are disposed of. I'm not
Okay.
quite sure.
PTR, could you educate me a little bit further, please?
It looks like he cannot be,
So you're saying I can't find an on-view violation until the case?
until,
Yeah.
yes,
All right, so I'll
until
look-
the current case is,
All right, so Madam Clerk, in 2019 CF 1106, I'll take no action, and I'll vacate my order of yesterday wherein I found an on-view violation and held him without bond. Do you understand what I'm saying? Okay. I'm going to vacate my order of yesterday, finding a violation and holding him without bond in 2019 CF 1106. I'm taking no action. All right, and that's all you really need to put on there. All right, thank you.
Thank you, Your Honor.
All right, the last one we have is with the Creole interpreter.
Yes, Your Honor, that's the only one I have left as well.
All right, stand by until we can get the Creole interpreter on the line, please.
Yes, Your Honor.
do him first then. After let's get up this individual, please. Jadine, the Creole interpreter defendant. give you an idea how long. Is it talk or is it interpreted? Hello?
Hello?
Hi, to whom am I
Yes,
speaking,
I'll be your
please?
Haitian Creole interpreter.
Say it again, please.
Yes, I will be your Haitian Creole interpreter.
And your name, please?
Celia, S-E-L-I-A.
All right. And is that your full name?
Gomez, G-O-M-E-S.
All right. Ma'am, have you been previously sworn in?
Excuse me, no.
Raise your right hand to be sworn in, please. Do you
did.
solemnly swear or affirm that you will truthfully translate from Creole to English and English to Creole? So help you God.
Yes,
All right.
yes, I do, I swear.
All right, so Madam Interpreter, we have two cases, all right, and I will pause, and when I pause, that is your cue to go ahead and translate what I say, all right?
Okay?
All right, first up is Ceylon Fleudort, F-L-E-U-R-I-D-O-R-T. Is that your name, sir?
Yes.
Silon Fleudery, c'est ça, c'est comme ça vous relez, monsieur?
Oui.
Yes.
Sir, I've reviewed a probable cause charging affidavit. It charges you with battery.
Oui, moi j'ai révisé accusation, et accusation c'est battre ou battre moun.
I do find probable cause.
Moi joigne yon cause.
All right. Does he qualify for the services of a court-appointed attorney?
Est-ce que vous qualifiez pour
Yes,
yon
Your Honor.
capable ou avocat?
All right, sir, I do appoint the Office of the Public Defender to represent you.
Oui, moi parle assigner un avocat défenseur pour yon capable défendre nous.
I am going to release you to pretrial release without monetary conditions.
Moi parle libérer ou capable aller dans le tribunal avant sans surveillance.
However, until further order of the court, you may not have any contact with the named victim in the matter.
Et jusqu'à ce que vous allez dans le tribunal, vous pas devez gagner contact avec monde qui est victime non.
You may not return to the named address.
Vous pas devez retourner dans l'adresse là, je t'ai mentionné.
You must maintain a separate residence.
C'est pour rester dans l'autre caille.
Please stay in contact with the attorney that's assigned to you from the Office of the Public Defender.
C'est pour rester en contact avec avocat défenseur yo assigné ou.
Please advise that office as well as the court clerk of a
S'il vous plaît,
mailing,
c'est pour aviser, s'il vous plaît, c'est pour aviser officier et puis secrétaire tribunal là.
of a mailing address where you can receive paperwork.
C'est pour aviser officier et puis secrétaire tribunal là, adresse ou côté où capable de joindre un document ou bien lettre.
Now, PTR, is there a problem with him being on PTR without knowing his address at this moment in time?
Your Honor, he doesn't qualify for a non-monetary release on PTR. He does qualify for PTR. However, because of the nature of the offense, it has to be monetary.
All right, I'll set bond in the sum of $100 plus PTR. Did you understand all of that, sir? Madam Interpreter, could you tell him, Madam Interpreter, could you tell him that I
Yes,
set
go ahead,
bond
ma'am.
in the sum of $100 plus pretrial release?
Oui, donc il va mettre une caution de $700 et puis il y a une libération avant tribunal ou bien avant audience.
Sir, do you have any questions?
Monsieur, est-ce que vous avez une question? Allô?
He's conferring with his attorney.
Okay.
Your Honor, I was confirming that he is not allowed to speak with his wife until further court order.
Until further court order, okay? All right, thank you, sir. All right, that concludes my business with Osceola County. Madam Interpreter, could you please stand by? We have one more case for you.
Okay.
Thank you, Your Honor.
Thank you. All right, ma'am, please tell me your name.
Fedling Tirano.
All right. I've reviewed a probable cause charging affidavit that charges you with battery domestic violence.
Oui, moi révisé un dossier et puis moi que c'était une violence domestique.
All right, she qualifies for pretrial release. Could you please tell her she qualifies for pretrial release?
Oh, sorry, yeah. Vous qualifiez pour y libérer ou avant audience là?
Ma'am, I do not want you to return to the scene of the offense. In other words, you may not return home, okay?
So, madame, moi pas voulu pour retourner la caille, d'accord?
D'accord.
Okay.
According to this affidavit, you're 7 months pregnant. Is that accurate?
D'après document ça, affidavit ou enceinte de 7 mois, n'est-ce pas?
Oui.
Yes.
All right. Do you have someplace you can stay?
Est-ce que vous avez un côté pour arrêter?
Yes.
Okay. And is that with a relative or a friend?
Est-ce que c'est vos amis ou bien famille?
Papa.
My father.
Okay. All right. And you have some children in common with your husband, correct?
Et vous avez un petit monde avec Marie, n'est-ce pas?
Oui, nous pouvons gagner.
Yes, we will have.
All right. Sir, tell me your name.
Giovanni Fano.
And do you need an interpreter, sir, or can you speak English?
I can speak English.
All right, so I won't need your services until I tell you again
Okay, ma'am.
during this case. I'm going to speak to the father now. Sir, I've reviewed a probable cause charging affidavit that basically outlines a dispute, a physical fight between you and, is it your wife? Are you all legally married?
No, ma'am.
Okay. So the mother of your child, correct?
Yes, ma'am.
All right. Are you in fear of her?
What's that?
Are you in fear of her?
I don't understand that. Sorry.
Okay. All right. Do you want her to return home?
Yes, ma'am.
All right. Madam Interpreter, please interpret that I ask him if F, he wants this defendant to return home, and he has indicated he does.
Oui, moi j'ai demandé lui si il voulait pour retourner la caille et puis il dit oui.
All right. And sir, why do you want her to return home?
Because she shouldn't get arrested in the first place. It was just an argument, and I told the cops not to get her, so they get her anyway. She
Okay.
shouldn't get arrested. It wasn't such a big deal.
Madam Interpreter, did you understand everything he said?
No, actually.
All right. If you could interpret the following to her, I asked him why he wanted her to return home. He said because the fight wasn't such a big deal, and she shouldn't have been arrested for it. That's in essence what he said.
Yes, Your Honor.
Oui, oui, moi j'ai demandé monsieur pour qui ça lui voulait pour retourner la caille. Il dit que ça nous te gagne, conversation nous te gagne, il pas très grave et il pas supposé arrêter.
Sir, who is Brianna?
She's her daughter.
Could you interpret that, Madam Interpreter, please?
Oui, il demandé monsieur à qui est-ce qui Brianna, monsieur a dit c'est petite fille.
All right. And where is Brianna living right now, sir?
I think she's with her
Il
father.
connaît Brianna Yekunia.
All right. Ma'am, do you know where your daughter, Brianna, is living right now? And
Yeah.
Madam Interpreter, I'm addressing this question to the defendant, so if you could interpret that, please.
Oui. Madame, est-ce que vous connaissez côté petite fille ou lié Brianna lié Yekunia là?
Yes.
Where is your daughter living?
She's with
Côté
her father.
petite fille ou lié?
Li avec papa li.
She's with her father.
Are there any other children, ma'am, in the home that are your children other than Brianna?
À part Brianna, est-ce que il y a l'autre petit monde qui la caillou, qui petit tout?
No.
No.
And ma'am, do you want to return to the home?
Madame, est-ce que vous voulez retourner la caille là?
Oui.
Yes.
Why?
Pour qui ça?
Why?
Your Honor,
Parce que
I'm just a little concerned that she may accidentally give incriminating information without.
That's not a problem at all. I'll
Intended
strike
to.
anything from the record in order that it not be used against her in any future proceeding.
pou ki sa moun retourne la kay mwen paske cause Brianna papa li pat mwen enceinte and so mwen pat reme rete la pou mwen ta fe petit lan.
Pas ta rete qui côté?
Mwen ta reme like pou mwen rete la mwen fe petit lan and Brianna, so I have to take care of her because I got nobody to take care of her.
Yeah, I would like to say to return home because I am pregnant and I would like to take care of Brianna. I don't have no one else that can take care of her.
Ma'am, are you under a doctor's care for your pregnancy?
Yes.
Madame, est-ce que vous avez suivi un docteur pour grossesse là?
Oui.
And
Yes.
you're, okay, and you're currently unemployed?
Et kounia ou pas travail?
No.
No.
Do you have a job?
Vous avez un travail?
No.
No.
Sir, I'm directing this question to you. Has there been any history of domestic violence between the two of you?
No, that's the first time. I
This is-
understand that she was just trying to protect her children.
I'm sorry, what did you say?
That's the first time.
All right. Madam Interpreter, if you could interpret the following. Ma'am, I'm going to go ahead and release you to pretrial release in this matter.
Ouais, moi pas libérer pour audience avant audience pour dossier ça.
Special conditions of your release
Condition pour libération.
will be that you have no hostile contact,
I'm sorry, can you repeat that, Your Honor?
will be that you have no hostile contact with the victim,
C'est pour pas gagner contact avec victime, non?
that means no yelling, no screaming, no punching, no kicking, no biting.
C'est-à-dire pour pas reler, pour pas batailler avec lui, pour pas frappé li.
All right, you will not be in possession of any weapons or any firearms.
Ou pas gen droit gen aucun arme ou bien aucun couteau, bagay comme ça, ou bien arme à feu.
Now, PTR, do you require bond in this matter plus PTR, or is PTR straight release sufficient?
Just picture.
Okay. All right, ma'am, I am going to find that you are indigent within the meaning of the statute and appoint the Office of the Public Defender to represent you.
I'm sorry, ma'am, Your Honor, can you repeat one more time?
Tell her I'm appointing the Office of the Public Defender to represent her.
Ok, moi pas assigner un avocat défenseur pour yo capable représenter ou.
Please keep your contact information current with both the clerk of the court as well as your attorney.
Et s'il vous plaît, c'est pour kembe tout contact ou information correcte pour bay secrétaire et puis avocat.
All right. All right, thank you both.
Merci pour tous deux.
Thank you, Madam Interpreter.
You're welcome, Your Honor. Thank you for using our service. Bye-bye.
Bye-bye. Just, the only condition of her release is no hostile contact. And no weapons. I don't think oh yeah, did I say that? I did. No weapons and no firearms. Just let me know whenever you're ready. If you want to take a break before? You can. All right, so when you're ready, we'll get the Spanish interpreter on the phone. Hang on a second. Mr. Interpreter, are you on the overhead?
Yes, Your Honor, interpreter standing by.
Okay. All right, sir, tell me your name.
Edivaldo Bautista.
Edivaldo Bautista.
All right, sir, I'm looking at a probable cause charging affidavit that charges you with battery, witness tampering, and stalking, domestic violence. All right, I find probable cause as to battery. I do not find probable cause as to, well, I'll let the defense, do you have any argument as to probable cause?
I didn't, Your Honor.
State, where's the witness tampering?
Your Honor, please stated that the defendant attempted to stop Sosa from coming to the police department to report the previous battery.
So the stalking is the fact that he was trying to stop her numerous times, I suppose?
Yes, Your Honor.
All right, it's extremely weak. But I'll go ahead and find probable cause as to each. Sir, I am going to grant bond in this case. As to count 1, bond will be set in the sum of $100. As to count 2, $100. As to count 3, $100. You are not to have any contact with the victim in the matter. Mr. Interpreter?
Yes, Your Honor.
You're interpreting that through the headsets?
Yes, Your Honor, simultaneously. Yes.
All right, thank you. Sir, no contact means no direct contact or no indirect contact. You are not to be in possession of any weapons or any firearms. You are to maintain a separate residence. And you are not to consume or be in possession of any alcohol or visit places where their primary source of revenue is from the sale of alcoholic beverages. All right, thank you, sir. I will appoint the Office of Public Defender to represent you.
Your Honor, Mr. Bautista, does he have a case number? Couldn't find it here on the report.
I have an agency case number. Oh, I see now. 19 CF 12424.
Thank you, Your Honor.
Thank you.
Welcome.
Sir, if you could take the headsets off, or is this?
Quítese, Your Honor.
Next up, we have Mr. Italo Taboa Calderon.
Yes.
Do you need an interpreter, sir?
Yes.
Yes, Taboga Calderon.
All right, sir, I reviewed a probable cause charging affidavit that charges you with battery, domestic violence. I do find probable cause. Does he qualify for the services of a court-appointed attorney?
Your Honor, the social worker doing affidavits in the back doesn't speak Spanish, and mine's not good enough to
Okay.
do a proper inquiry in the back.
Sir, I'm going to provisionally appoint the Office of the Public Defender to represent you in the matter. Bond will be set in the sum of $100. I am going to require that
Okay.
you not have any contact whatsoever with the named victim, maintain separate residences, not be in possession of any weapons or any firearms. All right,
Okay.
Judge, did you see that he qualified for a PTR?
hang on one second. All right, sir, you do qualify for, thank you, you do qualify for pretrial release, so I will vacate the order of $100 bond, and I will straight release you to pretrial release. Same conditions as I previously imposed upon you, sir. Thank you.
I have a question.
Yes, sir.
¿Por cuánto tiempo no voy a poder ir a mi casa?
For how long am I going to be away from my home? When am I going to be able to come back?
Sir, there is no victim here present. I can't take any input from her this morning to determine whether or not she is in fear of you. So in answer to your question, it'll be whenever a judge orders that you can return and/or whenever a judge orders that you can have contact, all right? You've been appointed an attorney from the Office of the Public Defender. I want you to stay in close contact with that office. Any new address that you have, you're going to have to update that attorney with it as well as the court file. All court dates will be sent to the address that we have of record inside the court file. So if you don't update your address, it's going to be sent to the address we have on record, which right now is 3974 South Orange Blossom Trail, okay? I'm sorry, I don't know, I don't think that was the address. Whatever address is on the police report is the address we have of record. All right, thank you.
So, Your Honor, Mr. Taboga Calderon's case number also is not here in the file either. Thank you.
How I can do that?
Yeah, Your Honor, I just was informing my new client that he can return with law enforcement with one time. Is that consistent with the court's order?
In terms of what I reviewed in the probable cause charging affidavit, I would allow that. So, sir, I'll grant your request for a one-time return with law enforcement to collect your personal belongings, okay?
Sir, entonces a pedido de la Defensoría, usted se le permitirá volver una vez a su casa con el propósito de recoger sus pertenencias con la asistencia de un oficial de la policía después de revisar el affidavit. Así que lo voy a permitir. Ok. Gracias.
Thank you.
Juan Ramon Ortega?
Oh, I'm sorry.
Sir, tell me your name.
Juan Ramón Duarte Arteaga.
Juan Ramón Duarte Arteaga.
Así es.
Sir, I reviewed a probable cause charging affidavit that charges you with robbery. I do find probable cause. I will provisionally appoint the Office of the Public Defender to represent you. With regard to this matter, bond is set at $5,000. It will remain. Conditions of your release will be that you not return to the scene of the offense. You not be in possession of any weapons or any firearms. You not have any contact with the victim in the matter.
Your Honor, would the court be inclined to reduce that number given his lack of criminal history?
Okay.
No. I would not.
You're all set.
Not any here.
Okay.
Alexander Rivera?
Okay.
So, Mr. Arteaga's case number, Madam Clerk.
19 CF 12401.
Thank you.
or something like that.
Sir, you Alexander Rivera?
No.
Alexander Rivera refused, Your Honor.
No.
Alexander Rivera is refused. Reset tomorrow. Are you Jose Rodriguez Vega?
Sí.
Is that yes? Okay. Mr. Interpreter, do you have the case number on this one?
No, Your Honor.
19 CF 12388.
Thank you, Your Honor.
Sir, I reviewed a probable cause charging affidavit that charges you with possession of alplazoram. I do find probable cause. I will provisionally appoint the Office of the Public Defender to represent you in the matter. I am going to reduce bond in this matter to the sum of $100. Special conditions of your release will be that you not be in possession of any controlled substance that is not legally and validly prescribed to you by a physician. Please stay in close contact with the attorney from the Office of the Public Defender. I do provisionally appoint that office to represent you. Keep them updated as to every change of address that you might have.
Okay. La abogada de la oficina de pública sí.
This is an extraordinary people that get interpreters.
Sí.
I can pay
Yes.
for me
Yes.
because I'm not having nobody.
All right, next up I have Jose Chavez Saldana. Do you
Sí.
need the case number, Mr. Interpreter?
Sí.
19 CT 6423.
Thank you, Your Honor.
Sir, I reviewed a probable cause charging affidavit that charges you with no valid driver's license. I do find probable cause. I'll provisionally appoint the Office of the Public Defender to represent you in the matter. Bond is set in the matter of, in the sum of $500. It will remain.
Your Honor, if Mr. Chavez can provide the court with community ties information on the record, would the court consider releasing him on his own recognizance?
State, was he charged with a DUI by separate affidavit? It says not pursued, never mind, it says DUI was not pursued. No, I think bond in the sum of $500 in this matter is reasonable, okay?
Okay.
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 ¿Puedo hablar?
Can I say something?
Yes, sir.
No tengo ningún contacto para hablarle a alguien. Yo necesito que el teléfono mío le pongan carga para sacar un número de teléfono.
I don't have anybody that I can contact with right away. I would need my phone to be charged in order for me to get a contact from there.
If the interpreter could just tell Mr. Chavez that he can talk to the jail staff about doing a property release, and he'll have access to a phone later.
Sir, do you know any of the telephone numbers, or are all those contacts in your telephone?
Ninguno.
None of them.
Solo necesito un número para yo hablarle y vengan a pagar la fianza. Yo tengo el dinero en la casa.
I do have the money at home, but there is one number that I need from there so I can call
All right.
and they can come in.
So I will order the jail to, under their supervision, allow him to access the telephone to obtain that contact number, and then the telephone will be turned back off, and then he can call from here, okay?
Thank you.
All right, thank you.
Thank you.
Iris Padilla Figueroa,
She don't need the Spanish interpreter, Your Honor, her victim does.
all right. Sir, this, Mr. Interpreter, it's the victim that needs the services of the interpreter, so I'll tell you when I speak to him, okay?
Very well, Your Honor.
Ma'am, tell me your name.
Iris
Adela Figueroa.
All right, I've reviewed a probable cause charging affidavit, ma'am, that charges you with battery, domestic violence. I do find probable cause. I will appoint the Office of the Public Defender to represent you in this matter. All right, we do have the victim present. Sir, tell me your name.
Señor, dígame su nombre.
Jan Padilla.
Jan Padilla.
What do you want to say to the court, sir?
¿Qué quiere decir usted ante el tribunal, señor?
¿Perdona?
¿Qué quiere decir ante el tribunal, señor?
No, que se resuelva todo.
For everything to be resolved.
I don't know what that means, sir.
Señor, no entiendo qué es lo que quiere decir con eso.
Yo quiero que ella salga y ya, y resolvamos las cosas.
Well, for her to get out and we resolve things.
All right. Anything further?
¿Algo más?
No, eso es todo.
No, that's all.
Okay, thank you. All
Bien,
right, ma'am.
gracias.
With regard to this case, it does look like you qualify for pretrial release, so I'll release you to pretrial release without monetary conditions. I am not inclined to allow her to go back to the same residence. You will both maintain separate residences. And with regard to contact, sir, do you want her to have any contact with you? Mr. Interpreter, I'm referring to the victim.
Señor, ¿usted quiere que ella tenga algún contacto con usted?
Sí, yo quiero que ella regrese a la casa, sí.
Yes, I want for her to come back home. Yes.
Sir, in light of what I'm reading, I'm not predisposed to allow y'all to reside in the same residence. Do you have any children that you have together?
Señor, tomando en cuenta el caso que tengo ante mí, yo no estoy dispuesta a permitir que estén en la misma residencia. ¿Ustedes tienen niños en común?
No.
No.
So you'll maintain separate residences. I will allow non-hostile contact.
Van a mantener las residencias por separado, pero sí voy a permitir que haya contacto sin hostilidades.
All right, ma'am, you are not to be in possession of any weapons or any firearms.
Yes, ma'am.
Judge, can you have her to provide an address, alternate address? If not, we need PTR or bond.
All right. Ma'am, do you know of an address where you will be staying?
I need the phone number to the
For the record, the,
phone number and the person's first and last name.
I don't know her phone number.
the defendant has provided PTR with an address. What's the name of the person?
Lisbeth Marine.
Lisbeth? Marine. Last name?
Yeah, it's her last name. Marine.
Marine? Oh. Okay, the person is Lisbeth Marine, and the address is 8438 Valencia College Lane, apartment 201, Orlando, Florida 32825.
We need a phone number too. We have to verify that it's okay that she can stay there.
Ma'am, I'm going to set bond in the sum of $100. All right, $100 bond or pretrial release, okay?
Yes, ma'am.
All right, thank you. Yeah, this says move up. Do they also need the interpreter? These ones? They gonna, back to that, these are the interpreters.
Or someone else can post it for you.
This was Miss, this was Iris Pagilla, was the last one I did. We don't need the interpreter for any other of the defendants, Ms. Taylor?
No.
All
We're
right.
all set, Your Honor, thank you.
All right, Mr. Interpreter, we don't need your services any longer. Thank you so much.
You're very welcome, Your Honor.
All right, sir, tell me your name.
Christopher Disdier Bizarre.
He's under felony domestic, Your Honor.
I'm just looking for the PTR information sheet that I would have on him, and I'm not finding it in the move-ups. That's what I'm doing next, right, the move-ups? PTR, I'll just ask you for a prior history on him. I don't have the form in front of me. I don't know what I've done with it if I had it. All right, sir, I'm looking at a probable cause charging affidavit that charges you with battery, domestic violence by strangulation. Give me a moment, please. All right, I do find probable cause. I will provisionally appoint the Office of the Public Defender to represent you, sir. All right, ma'am, what is your name?
Kiara Chico.
All right. Raise your right hand to be sworn. Do you swear or affirm the information you're about to provide will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
All right, so ma'am, what is it that you want to tell the court?
I would like his charges to be dropped, but I do want to put a restraining order on him. I don't want him to come back to the home, and I don't want to be around him. I do not feel safe around him.
Well, you know, with regard to a restraining order, you go down to the Orange County Courthouse, and you can apply at that courthouse for a temporary restraining order. All right, anything further that you want me to know, ma'am?
No.
All right. Thank you. All right, I'll set bond in the matter in the sum of $2,500. Conditions of your release, sir, will be that you have no contact whatsoever with this young lady. That means no direct contact, no indirect contact, no posting things on social media designed to get word to her. You will not be able to return to the address. You will maintain a separate residence. You will not be in possession of any firearms or any weapons. I will, as I said, provisionally appoint the Office of the Public Defender to represent you in the matter. Thank you, sir. Philip Martin?
Yes, ma'am.
All right, so I reviewed a probable cause charging affidavit that charges you with aggravated assault on a law enforcement officer. I do find probable cause. I will appoint the Office of the Public Defender to represent you in the matter. All right, bond will remain in the sum of $5,000. Special conditions of your release, sir, would be that you not return to the scene of the offense. You have no contact with the law enforcement officer named, as well as no contact with one Dennis Morris.
Yes, ma'am.
Not be in possession of any firearms, any weapons, not be in possession of any alcohol that's,
Down here from North
not
Carolina.
visit places where their primary source of revenue is from the sale of alcoholic beverages.
Your Honor, Mr. Martins informed me that he can't afford the bond as currently set and that he's on disability through Social Security, and that his income is entirely dependent on that check, and so we'd just be asking for a reduction on those grounds.
So you can apply to the judge that it's assigned to for a reduction, but at this point in time, I am not willing to reduce it, okay?
Thank you, ma'am.
Thank you. Angel Lewis Capel Santiago, no,
Talk to the judge first?
I'm sorry? No. All right. So it'll be reset for tomorrow because he's in medical?
I still don't know what's going on.
You Nicole Griggs?
Yes, I am.
Ma'am, a judge has previously signed a warrant for your arrest, having previously found probable cause for written threats to kill.
I haven't made any of those. I'm confused.
Ma'am, I can read this to you if you wish. I'd be more than happy to do that. You want me to read this to you? The
Please.
affidavit that the judge had in front of her before she signed the warrant for your arrest. Do you want me to read it to you so that you can be apprised of what she had in front
Yeah,
of her?
I am very confused, truly.
Okay, I'll be happy to do that, but I don't want you to talk about it, all right? I'm just gonna read it to you. Don't deny it, don't admit it, just listen, okay? All right, it reads as follows. On August the 28th, 2019, at approximately 1700 hours, defendant Nicole Griggs entered the Florida College of Integrative Medicine at 7100 Lake Eleanor Drive in Orlando, Florida. Griggs entered the school to follow up on acupuncture treatment for her maladies. She was unsatisfied with her experience at the acupuncture school and spoke with staff members. During Griggs' entire visit, she live streamed video and audio the encounter with the social media application Periscope. Periscope allows the user to broadcast video, audio of their experiences and share them with fellow followers, both live and archived. Griggs has 4,309 followers on her Periscope account. The Orange County Sheriff's Office was contacted by Detective Lori Fariona of the Orlando Police Department. Detective Fariona is an investigator who specializes in cyber internet-based crime. She was watching the live stream of Griggs' visit to the Florida College of Integrative Medicine via the internet. She observed what she believed to be Griggs making threats to the school staff to kill them and to go get her gun and return to the school and kill them. Detective Fariona noted the school was within the jurisdictional boundaries of Orange County Sheriff's Department and requested we investigate the threat. The affiant was contacted by deputies who responded to the Florida College of Integrative Medicine. They noted Griggs was known to the school, having been a patient who has been treated there numerous times over the years. She was known by the name, identifying data, and contact information. She was positively identified by school staff related to this incident. Staff members provided a sworn statement confirming that Griggs was unhappy with her treatment at the school. Griggs had made statements which were taken as broadly threatening by the school staff, including statements such as if they did not fix her, bad things would happen to them. These witnesses are willing to testify in court, and then it goes on, all right? So that's what the judge had in front of her when she issued it. I'm not here to tell you the accuracy of it, the truth of it, the
I only
falseness
meant
of
the
it.
hurricane,
None of
not
that is for-
myself.
None of that is for today,
Just
okay?
don't do it today.
Oh,
So I
not
am,
me.
I am going to go ahead
don't-
and grant bond in the matter. I will appoint the Office of the Public Defender to represent you. As far as bond in the matter, however, it will be in the sum of $5,000. I do want a mental health screening, if one has not already been done in this matter. Special conditions of your release will be that you not return to this school. You not have any contact with any of the individuals named in the affidavit, that you not post anything on social media that is designed to get word to them or anything about them. All right? You are not to be in possession of any weapons or any firearms.
I don't, it's not,
All right, and I want a mental health
I meant
screening.
the hurricane,
No,
no.
it's really okay.
I'm sorry?
It's okay. It's okay.
Okay. No, thank you. All right, thank you, ma'am.
It's not for today. All right. You'll be all right. You'll be all right.
Jacqueline Pacheco?
Yes, ma'am.
All right, ma'am. You were detained on a warrant for failure to appear. Looks like it was for arraignment on August the 20th. The issuing judge set bond in the sum of $250 in that matter. It will remain in that amount. And there's a mental health screen, or there was yesterday, is that what this is telling me? PTR?
It has a mental health hold.
Just a mental health hold, okay. All right. All right, I will appoint the Office of the Public Defender to represent you, ma'am. Thank you. Jesse Barney.
Yes, ma'am.
Good morning, sir.
Good morning, ma'am.
You've been detained for soliciting without a permit in violation of county ordinance. I do find probable cause. Is this a resolvable offense?
Yes, Your Honor.
Okay.
It's very similar to the cases we had yesterday, just the county's version of the panhandling. Mr. Barney did let me know that he wanted to resolve the case.
Is that what you want to do, Mr. Barney?
Yes, ma'am.
There's a form in front of you. It's a plea form. Could you read over that? And if that's what you want to do, sign it. I'll just time serve you, adjudicate you, reduce the court cost to a civil judgment.
My pants should be here. Hold them up.
All right, sir. Did you sign this form?
Yes, ma'am.
All right, you understand the rights that you're giving up when you enter a plea?
Do you understand the rights you're giving
Yes,
them?
ma'am.
Okay. All right, sir, I am going to adjudicate you guilty of soliciting without a permit, sentence you to the time that you've served in jail, and court costs in the matter. I will reduce the court cost to a civil judgment. Thank you, sir.
And Your Honor, just a heads up to the court, I did have a PC challenge on this case.
Okay. You can go ahead with your PC challenge.
Based on the four corners of the affidavit, I didn't see anywhere that tied Miss Battle to this specific robbery. It appears that she was a passenger in a car. She wasn't seen anywhere near the offense, and there's no tie to the actual crime itself. So my argument would extend to count 1 and count 2.
State, do you wish to be heard?
Yes, 1 second, Your Honor. The officer does state that the defendant was in the vehicle. If the court requires more from the officer, I would ask for it to be reset for tomorrow.
Okay. All right. I do find that there is a lack of probable cause, as the attorneys indicated. The only evidence is that she was seated within a vehicle. So I'll give the state the 24 hours that they're asking for, and I'll reset it for tomorrow, okay?
In the meantime, Your Honor, will there be a bond amount set? Can we ROR her?
Not because of the following. What I'm looking at on the face sheet the PTR has provided me with is that she qualifies as a violent felony offender of special concern, so I am not going to do anything until tomorrow, okay? Michael Dowse?
Yes.
Sir, I'm looking at a probable cause charging affidavit that charges you with possession of cocaine. I do find probable cause. I will appoint the Office of the Public Defender to represent you in the matter. I will reduce bond in this matter to the sum of $500. Appoint the Office of the Public Defender if I haven't previously. Special conditions of your release will be that you not be in possession of any controlled substances that are not validly and legally prescribed to you by a physician. All right. Thank you. Jerome McGinnis? Mr. McGinnis, I reviewed a probable cause charging affidavit that charges you with burglary of a structure. I do find probable cause. I will appoint the Office of the Public Defender to represent you in the matter. Bond is set in the sum of $3,500. The bond will remain in that amount. Special conditions of your release will be that you not return to the scene of the offense. You have no contact with the listed witnesses or victims in the matter. Thank you. Javier Santiago? Mr. Santiago, a court has previously, or a magistrate has previously found probable cause to detain you. Has set bond at $0. The offense is a bomb threat. Give me a moment, please. appoint the Office of the Public Defender to represent you, sir. You are being held without bond. You will not have any bond in this matter. And give me 1 second. Is there I want him screened mental health wise. Has that been done yet?
No, it's not.
All right. And I
Well,
want him,
he had a hold, but the hold has been released.
right, but I want him seen by mental health professionals in the jail. Can that be done?
They screened him.
They did screen him?
Yes.
Okay. All right, answers my question.
And Your Honor, based on the statute that this is charged under, it appears as though this is a second-degree felony, and so Mr. Santiago would be entitled to a bond. This isn't an offense that's punishable by life. The state hasn't moved to file a pretrial detention motion, and so at this point, he would be entitled to a bond.
I am finding that based on the four corners of the affidavit, he presents a significant risk and threat of immediate danger to the community. And I will grant your request to set bond. I will set bond in the sum of $500,000 with conditions that he not return to scene of the offense, not be in possession of any firearms, any weapons, any explosive devices, any weapons whatsoever. All right? Thank you.
Thank you, Your Honor.
And I do want paperwork to reflect that I find him to be a danger and threat to the community. Gregory Campbell?
Refuse, Your Honor.
All right, Mr. Campbell is a reset for tomorrow, we refused. You Charles Call?
He's medical, Your Honor.
Mr. Call is medical, reset for tomorrow. All right, so Oscar Walter?
Yes, ma'am.
All right, so you're being held on an allegation of violation of probation. The issuing court set bond in the sum of $2,000. Bond will remain in that amount. I will appoint the Office of the Public Defender to represent you in the matter. Thank you. All right, Madam Clerk. Deputies, I'd like to recall Javier Santiago before I go forward with this young lady. Javier Santiago. Madam Clerk, going to adjust the bond in that matter.
We have to go get the, he might have went back to the dorm already. It's gonna be a minute, Your Honor, because they got to
All right.
bring him back
Just let me
up.
know when he's back up,
Yes,
and then
ma'am.
I'll readdress him, okay?
Yes.
Quenisha Gatewood?
Yes, ma'am.
right, ma'am, I've reviewed a probable cause charging affidavit that charged you with aggravated assault with a deadly weapon. I do find probable cause. I will appoint the Office of the Public Defender to represent you in this matter. I am going to set bond in the matter in the sum of $5,000. Special conditions of your release will be that you not return to the scene of the offense. You have no contact whatsoever with Henry Snow or Deborah DeRozier. Do not be in possession of any weapons, any firearms, any scissors, any weapons at all. All right, ma'am, you have a significant history. You do qualify for pretrial release. I will release you to pretrial release as opposed to giving you the bond. Another condition of your pretrial release, however, will be that you submit to random urinalyses, okay? And again, ma'am, no contact,
That's
okay?
okay, thank you.
Now we got Mr. Santiago back.
Thank you.
All right, thank you.
Thank you.
All right, recalling Javier Santiago. All right, Mr. Santiago, I have rethought the amount of bond that I set in this matter, and I think the more appropriate amount to protect the community is $1 million. So bond is increased to $1 million in that matter. All right, thank you. This is Ms. Gatewood. Juliet Vega?
Yes, ma'am.
All right, Ms. Vega, I've reviewed a probable cause charging affidavit that charges you with attempted first-degree murder with a weapon. I do find probable cause. All right, so this would be a violation of 782.04, and it is an attempt. So state, what is the level of offense that would become if filed on as charged? Is it an F1 PBL? Is it an F1? Is it an F2? What is it?
It would be an F1, Your Honor.
Would it be a PBL? Would it be punishable by life?
Yes, Your Honor.
Ms. Taylor, the children that were inside the apartment, are they the biological children of this defendant?
Just a moment, Your Honor. Your Honor, my understanding is that the children are, that there are 3 children and that they are shared between my client and the victim.
All right, where the pretrial release form indicates that there is no prior conviction history in this matter. Victim contact was not made. All right, ma'am, in this matter, I am going to grant bond. I'll appoint the Office of the Public Defender to represent you. I am going to grant bond in the matter in the sum of $500,000. Conditions of your release will be that you not return, you have no contact with the named victim, do not be in possession of any weapons, any knives, any firearms, anything of that nature. Thank you.
Your Honor, and thank you for the moment. I just had one point as to
I'm sorry, I was moving on to the next one. You're still on,
Yes, Your
still on
Honor.
Juliet Vega?
I apologize, Ms. Vega. As to the court's finding of probable cause, I just wanted to raise brief argument as to the premeditation element that would be required.
That's not a proper subject for probable cause, though. I mean, truly. But go ahead. I'll let you make your record.
Thank you. Just that there's nothing within the 4 corners of the affidavit that would support a finding of attempted first-degree murder as named in the statute charged under 782.041A. And that's all I have. Thank you, Your Honor.
All right. The affidavit that I read indicates that as the victim was holding on during this argument to the defendant, he advised that he felt her stab him 3 times in the left thigh with a knife, and he was in and out of consciousness due to the injuries sustained. So I do find that there's enough probable cause there to find premeditation for the purposes of this particular hearing. Okay.
I understand. Thank
All
you.
right, thank you.
Okay.
Michaela Winter?
Yes, ma'am.
All right. Ma'am, I've reviewed a probable cause charging affidavit. It charges you with aggravated assault and domestic violence battery. I do find probable cause. I do appoint the Office of the Public Defender to represent you in this matter. All right, ma'am, I am going to set bond in count 1 in the sum of $500, count 2, $500. Special conditions of your release will be that you have absolutely no contact whatsoever with your sister in this matter. You not return to the scene of the offense. You maintain separate residences, and no contact doesn't include no posting things on social media designed to get to her. No contact is no contact. You understand that?
Yes, ma'am.
All right. All right, thank you, ma'am. Sir, are you Deontay Cesar?
Yes, ma'am.
All right, so I reviewed a probable cause charging affidavit, and it charges you with battery domestic violence. I do find probable cause. Appoint the Office of the Public Defender to represent you in the matter. I will set bond in the matter in the sum of $500. Require that you not return, have no contact with the victim, not be in possession of any weapons or any firearms. Appears at the time of this offense, you were out on bond in 2019 CF 6117 for the offenses of possession of cannabis with intent and possession of cannabis. I do find a violation of your pretrial release, forfeit and street your bond, and hold you on no bond status with regard to that case.
1 second.
Thank you.
And Your Honor, just briefly, if I could be heard as to the out and bound case.
All right, the possession of cannabis case you're talking about?
Yes, Your Honor. In that case, the 19 CF 6117 AO, the state has not filed charges. Looks like the date of arrest was in April, and there's still no information filed, so I would just ask the court, based on that information, to consider resetting a new bond upon the revocation.
State, is that accurate? This was filed on in April, and there's still, or he was arrested in April, and there's no information that's been filed in that as a possession of cannabis?
I'm sorry, Your Honor, I'm not following. Which case is that?
This is 2019 CF 6117. Defense is saying that he was arrested back in April on that, and the state still hasn't filed an information? Is he gone into a diversionary program with it? Sir, did you enter into a diversion with that case?
Ma'am, all I did was pay a bond and get out.
All right, so you have not entered into diversion?
Nah, because I was with somebody that caught that charge.
Okay.
That's correct, Your Honor, and I don't have any information as to why the filing decision has not been made yet.
Okay. All right, then I will go ahead and grant bond in 2019 CF 6117. I'll grant it to, and the total sum of, was $1,000 each before, it looks like, right? You total of a $2,000 bond before, right, sir? Okay, so it'd be a total of $4,000, $2,000 each count. Special conditions of your release, sir, that would be that you not be in possession of any controlled substances that are not legally and validly prescribed to you by a physician.
Your Honor, May the state request that we recall Juliet Vega, 19 CF 12402?
All right. So Ms. Vega needs to come up.
We'll have to go back and get her, she already went back to her housing unit.
So tell me,
well-
proffer to me what you wanted to talk about.
Yeah, the state would just want put on record that the state requests that this case be set at no bond since it's punishable by life.
I reviewed the facts of it, and I think I gave her, what, a 500,000? Okay. And for me to do no bond would be proof evident presumption grade, and it looked like it was pretty much a melee between the two of them as well.
Mhm.
So I'll respectfully decline to set no bond in the matter. I did think about it, but after reviewing everything and taking it all in and looking at her lack of substantial prior history, I decided to go ahead and set bond at $500,000.
Okay, thank you.
All right. Are you Mr. Doriston?
Yes, ma'am.
Okay. Sir, I reviewed a probable cause charging affidavit that charges you with domestic violence battery. I do find probable cause. I do appoint the Office of the Public Defender to represent you. There is also a warrant that was issued for your arrest for failure to appear. There is a bond set for $2,000 in that matter. The allegations that you failed to appear for arraignment set on a charge of resisting an officer without violence. The bond will remain as set on the warrant. With regard to the battery domestic violence case, I will set bond in the sum of $500, require that you not return to the scene of the offense. You maintain separate residences. Do not have any contact whatsoever with the named victim in the matter. That includes any third-party contact, asking people to get word to her, posting things on social media. You will not be in possession of any firearms or any weapons. You understand all of that?
Yeah, I understand, but Your Honor, I got all my clothes and my cars over there and everything. How should I take these back?
I'll give you the ability to return one time to the residence to get your personal effects with the assistance of law enforcement, okay? All right, thank you. Kenneth Grays,
Yes, sir.
how are you?
I'm fine. How are you?
Good, good.
Good.
All right, Mr. Grays, I'm looking at an affidavit that charges you with battery, dating violence. Give me a moment, please. Just, I'm gonna read it,
Oh, the
okay?
camera. Oh, no.
Yeah. Oh.
Thank you. That she initiated the action.
Mhm.
Right, okay. That's better.
All right, Mr. Grays, I have reviewed the affidavit, and I do find probable cause. I will appoint the Office of the Public Defender to represent you in the matter. All right, I'll set bond, sir, in the sum of $1,000. Special conditions of your release will be that you have no contact whatsoever with the victim in the matter, okay? I want you to maintain separate residences and not return to the scene of the offense.
Okay, thank you, Your Honor.
Do you have any questions about those conditions, Mr. Graves?
No questions,
Okay. All right. Thank you, sir. You can
Thank-
take the headsets off.
Thank you.
Are you Trentonio Thompson?
Yes, ma'am.
All right, sir, I reviewed a probable cause charging affidavit. It charges you with battery, dating violence. I did find probable cause. I will appoint the Office of the Public Defender to represent you in this matter. All right, so he qualifies for pretrial release. He does have somewhat of a history. All right, sir, I will release you to pretrial release with the following conditions. You will have absolutely no contact with the named victim, okay? That's not any direct contact, any indirect contact. You won't be in possession of any firearms or any weapons. All right, and that'll be all. Thank you, sir. PT bar.
So no bond, no nothing, anything released now.
It's not a trick.
Really?
Oh, that's okay. The judge is just gonna ask your name. And just a heads up, Your Honor, I do have one PC challenge for this case.
Okay, and you're talking about Mr. Aviles Rivera?
Yes, Your Honor.
Okay, give me a moment. All right, I'll hear from the defense.
Your Honor, I just have argument as to count one, the carrying concealed firearm. I would just argue that based on the affidavit, the firearm was viewable and out in the open and wouldn't meet the criteria for being concealed.
State?
The state argued it was concealed by being in the vehicle, and that might be an argument for purposes of proven guilt, but for purposes of ROR, I think the officer had probable cause.
All right, I note that the gun was located between the driver's seat and the center console, Glock 19, between the driver's seat and the center console, not under the seat, as indicated by the defendant. And it does state the extended magazine was protruding vertically between the seat and the center console and was in arm's reach. There's no indication that it was not, or it was something that was readily observable, so I am going to deny your request for the court not to find PC as to count 1, and I do find PC as to count 1 through 5 in the matter. All right, I will point the Office of the Public Defender bond is set as to count 1. I'm going to increase that to the sum of $3,500. As to count 2, it will remain in the sum of $150. Count 3 will be $150. Count 4 will be $150. And count 5 will remain at $150. Appears that at the time of this offense, he was out on bond in 2019 CF 906 bond for the offenses of possession of drug paraphernalia, possession of cannabis over 20 grams. I will revoke his bond, hold him on no bond in that matter. All right, anything further?
Just briefly, Your Honor, with regard to the out on bond case, I would just note for the court that the state has not made a filing decision. The date of arrest was June 25th, and there has not been an information filed, so I just request the court to consider setting a new bond.
All right, is that accurate?
I have clerks up if you want to just, sorry.
Yes, Your Honor.
Okay. All right, I note the nature of the charges and the fact that the state hasn't filed an information yet, so I will grant bond. I'll set bond in that matter. The previous bond amount was $2,000. I'll set it in the sum of $4,000. It looks like there were 3 things that he was picked up on, right? Possession of drug paraphernalia ×2 and possession of cannabis. Is that correct?
That's correct.
All right. So then bond will be $1,500 as to the possession of cannabis over 20 grams, and it will be set in the sum of $1,500 as to one drug paraphernalia count and $1,000 as to the other, for a total of $4,000. I think if I got my math right, that's $4,000.
That's right.
Special conditions of his release will be that he not be in possession of any narcotics that are not validly and legally prescribed to him by a physician.
Thank you, Your Honor.
Thank you. Possession, Andrew Bowman. Are you Mr. Bowman? All right, Mr. Bowman, I've reviewed a probable cause charging affidavit. It charges you with possession of methamphetamine with intent and simple possession. I do find probable cause. I will appoint the Office of the Public Defender to represent you in the matter. bond as to count 1 will remain in the sum of $15,000. As to count 2, it'll be $1,000. Special conditions of your release will be that you not be in possession of any controlled substances that are not legally and validly prescribed to you by a physician.
Your Honor, Mr. Bowman is requesting bond reduction and is willing to put information as to community ties on the record if the court would entertain it at this time.
I would rather him take that up with the judge that's assigned to the case, okay? Thank you. Andrea Schutz?
Andre.
I'm sorry?
Andre.
Andre, I'm sorry. All right, Schutz, is that correct?
Yes, ma'am.
All right. Sir, I've reviewed a probable cause charging affidavit that charges you with possession of MDMA. I do find probable cause. I will appoint the Office of the Public Defender to represent you in the matter. Bond will remain as set in the sum of $1,000. Special conditions of your release will be that you not be in possession of anything that's not validly and legally prescribed to you by a physician. Yes, sir.
Ma'am, I work at a sick on OBT by the post office, and I had just got to work. So it was a little trash round. So
Just don't talk about the facts of the case. Just talk about bond.
Sir, she's not trying to be rude to you. Everything here is being recorded. So if you say something about the facts of the case, it could be used against you in a future court date, okay? So she's just trying to protect your interest at this point in time. So if there's something that you want me to know, why don't you tell her first? And then she can tell me whether or not it's something I should know about.
if she can I got to work. I had just got to work. That was trash.
Okay. So I think his concern is that he wants to see if he qualifies for pretrial release, or if the court would consider ROR
Because my job.
to consider his circumstances, that he would lose his job if he's stuck in jail and he can't afford the monetary bond.
Because we just spent the money. I got paid Friday. And I haven't been in trouble in a minute, man.
Sir, what I'm looking at is a prior history of many drug convictions, and also that you've been to the Department of Corrections for sale of drugs. You failed to appear in court 3 times. So in light of everything, I think the $1,000 bond is reasonable, okay?
That was like 3, 4, 5. That was a long time ago.
I don't have the
I
dates.
haven't been in trouble in a while,
How long's a while?
like 3 years.
Well, again, I'm gonna leave it set in the sum of $1,000, okay? Thank you. Theodore Colley?
Yes, ma'am.
Sir, I reviewed a probable cause charging affidavit that charges you with possession of cocaine within 1,000 feet of a convenience store and trespass after warning in a convenience, in a conveyance, excuse me. I do find probable cause. I will appoint the Office of the Public Defender to represent you. As to count 1, I am going to reduce bond. I'm going to reduce bond in that case to the sum of $1,500. Count 2 will remain the sum of $100. Special conditions of your release will be you not return to the scene where you were stopped, that quick stop, and you not be in possession of anything that's not legally and validly prescribed to you by a physician. Appears that you were failed to appear for a charge of possession of drug paraphernalia. PTR, is that the 19 MM 4160 case that's noted?
Yes.
And he was out on ROR on that case. Do you know what he failed to appear for? Trying to find it on this form. I'm not seeing it right off.
Possession of drug paraphernalia.
No, I mean, was it like a arraignment, pretrial conference? Does your information tell you that?
It was supposed to be a plea or sentence.
826 was supposed to be a what? A plea? Okay.
And you released him yesterday.
I'm sorry?
I think this was that you released yesterday on ROR.
Did I release him yesterday on ROR? No. He came up before me yesterday,
Yes, ma'am.
and I released him ROR in that case?
I failed to appear. You released him ROR.
Okay, all right, I'll take no action on it then if that's what I did yesterday. All right, thank you, sir. Lum Garnett,
Yes, ma'am.
all right, sir, I reviewed a probable cause charging affidavit that charges you with burglary of a conveyance and petty theft. I do find probable cause. I will appoint the Office of the Public Defender to represent you in the matter. Bond will remain as set is in the sum of $3,500 as to count one, $250 as to count two. Special conditions of your release will be that you not return to the scene of the offense. You have no contact with the victim in the matter. The time of this arrest, you were out on bond in 2019 CF 10306. The offenses of resisting an officer without violence and burglary of a conveyance. I am going to revoke your release status in that matter and set bond at 0.
So I don't have a bond no more?
You have a bond on the new burglary of a conveyance, but you haven't got a bond on the old burglary of a conveyance.
So I can still bond out today?
You can bond out on the new charge that I just set $3,500 on,
Yes, 'cause
count
they were-
one. Sure, you can bond out on that one, but
They
you
were-
can't bond on the other, because
But
I've
I-
taken your bond.
But I
Taking
can
your-
get released though, right? I will get released today because they were gonna
No.
post it at 12?
No, if they post it, you're still gonna sit in jail.
All right, understood. So there's no way I can get out.
Yeah.
You won't get out on one of the two cases. So it won't do you any good to post bond on one of them because another one's gonna hold you, okay?
Understood.
All right, thank you.
So
Marcel
I'll let your attorney know.
Grackham?
He's mental health, Your Honor.
It's mental health.
We set him to tomorrow. Alonzo Green?
Yes, ma'am.
Mr. Green, I reviewed a probable cause charging affidavit that charges you with driving while license suspended with at least 2 prior convictions. do find probable cause. I will reduce bond in the matter to the sum of $1,000. The special conditions of your release will be that you not operate a motor vehicle without a valid and lawful license.
Yes, ma'am.
Thank you.
Thank you.
Michael Hoff.
Yeah, that main number, you'll find out who has your case.
Mr. Hoff, I reviewed a probable cause charging affidavit that charges you with possession of MDMA and possession of drug paraphernalia. I do find probable cause. I will appoint the Office of the Public Defender to represent you in the matter. All right, bond as to count one will remain in the sum of $1,000. Count two, 100. Special conditions of your release will be that you not be in possession of any substances that are not validly and legally prescribed to you by a physician. Thank you. Mr. Jernigan.
1 second, John.
Good morning, Mr. Jernigan. Sir, I've reviewed a probable cause charging affidavit that charges you with robbery with a deadly weapon, aggravated battery with a weapon, petty theft, and
With a weapon?
possession. Aggravated battery with a weapon?
No, no weapon.
All right, let me read this to you, okay? Mr. Jernigan and Mr. Robbins entered the supermarket and attempted to steal alcohol. In the process, a physical altercation ensued, at which point Mr. Jernigan used a bottle of Hennessy, that's the weapon they're talking about, okay? To batter the victim in the head and left the building along with Mr. Robinson. So I do find probable cause, sir. I will provisionally appoint the Office of the Public Defender to represent you.
I was tackled.
All right. Bond as to count one, sir, will be set in the sum of $7,500. As to count two, it will remain in the sum of $10,000. As to count three, 100. As to count four, 100. Special conditions of your release will be that you not be in possession of any weapons or any firearms. You not return to the scene of the offense. You not have any contact with the named victims in the matter, and furthermore, you not have any contact with the co-defendants in the matter, Rollins Robinson or Regina Battle. All right, thank you, sir. this Carl Jones?
Yes.
All right. Mr. Jones, I've reviewed an affidavit charging you with battery on a law enforcement officer, possession of drug paraphernalia, and resisting an officer without violence. I do find probable cause. All right, sir, bond will remain as set at $1,500 in count one, 100 in count two, 100 in count three. Special conditions of your release will be that you not be in possession of any weapons or any firearms.
Can I get you to reduce that bond so that I can try to get out on the 1,500 one?
Here's what I'm looking at, sir. I'm looking at your prior history, which is pretty extensive.
All it is
I'm
a
looking
bunch of
at the
misdemeanors.
nature of the prior offenses, not all of which are violent, but certainly some of which are violent. And I'm reading the probable cause charging affidavit. So, given all attendant facts and circumstances, I find that $1,500 on count one that is an amount that's reasonable and an amount that's needed to assure your presence in court. You do have, according to at least what I'm looking at in your prior history,
This is my first felony in about 15 years.
that might be, it doesn't tell me how old these felonies are, but it does indicate to me that you've got 3 prior failures to appear. So I do find that bond in those sums are reasonable. I do want to talk to you about 2019 MM 356. That is
They dropped the charges on that.
did they drop the charges on that?
Yeah, they did.
State? 19
They
MM
didn't even
356.
You check, Your Honor?
He bonded on 8/21.
Pick it up? Okay, well, why worry about it then?
Right, but he's telling me that they've dropped the charges since, so I just want
Yeah, well, they
to
haven't
double
picked it
check
up.
what he's saying.
What are you doing even worrying about it?
On 19 MM
I just wanted
356,
to
the state hasn't made a filing decision. It's not that the charges were dropped.
All right, and so the date of arrest according to PTR was 7/20 on that. All right, so sir, I'm going to revoke your release status in 2019 MM 356, and you'll be held without bond in that case, all right?
So what are you doing? If I can't bond out on this charge, is that what you're telling me?
Well, what's happening is, part of a condition of your release, whether it be ROR or whether it be on bond, is that you not violate the law. What has happened here is, after you were released in that misdemeanor case for trespass, now you've been arrested in this case with a battery on the law enforcement
So I
officer,
can't even
et
bond
cetera.
out on this?
So what I am doing is I am revoking your bond on that trespass, or revoking your release status, I should say, on that trespass that you were out on, and I've set bond in this new case. So the upshot of that, to answer your question, is you can bond out on the new law offense that you just got arrested for, but no, you're being held without bond on the other one. So, no, you will not be able to get out of jail, okay?
And Your
Right.
Honor, just for purposes of the record, the concern that I would have with the revocation in the MM case is the rule of procedure that governs the 33 and 40-day motions. The language states that a defendant, under no circumstances, can be held on a case after 40 days, and so since...
Consecutively. He was ROR.
I understand.
I don't find that applicable because the intent of that rule is so folks won't be held continuously in jail for over that 40-day mark without the state filing charges and without them being able to be released with regard to that. So he hasn't been held consecutively, so I don't find that to be applicable.
I understand.
All right, thank you. Ronnie Lester.
Yes.
Sir, I've reviewed a probable cause charging affidavit that charges you with burglary of a conveyance, possession of burglary tools, possession of drug paraphernalia, and resisting an officer without. I do find probable cause. I will appoint the Office of the Public Defender to represent you in this matter. As to count one, I'm reducing or setting bond in the sum of $1,500. As to count two, $100. As to count three, $100. And as to count four, $100. Special conditions of your release, sir, will be that you not have any contact with the victim in the matter, you not return to 1206 West Robinson Street, and that you not come within 500 feet of the food truck known as Simply Foods. Thank you. And are you Tamarick Mosley McNeil?
Yes.
Sir, a judge has previously found probable cause on the offense of sexual battery on a child under the age of 12. That is a capital felony, sir. Give me a moment, please. All right, I have reviewed the affidavit. I've reviewed the date of birth of the alleged victim that is stated on the affidavit. All right, sir, I do find proof evident, presumption great. I will continue to hold you without bond in the matter. If I didn't previously, I do appoint the Office of the Public Defender to represent him in the matter. Anything further?
Thank you, Your Honor. I just would request a couple of moments to review the warrant to see if I need to make any arguments to preserve the record on the issue of proof evident presumption, great.
Sure, if you wish to. I'll tell you what, we'll take a break. I'm about at a point where I need a break anyway. So we'll take a break for 15 minutes, and then we'll resume, okay? If you just give that one back, that piece of the affidavit back to me, so that she can make, so I can have it when she makes that argument.
I'm sorry? Do I need it?
Yeah.
No, I have it up. I have it on
Okay.
there.
I
Yeah.
was asking if-
Oh, yeah.
Thanks, Marie.
I know.
All right, we have Tamarick Mosley McNeil here. All right, you wanted to place an argument on the record with regard to the court's finding of proof evident presumption, great.
Yes, Your Honor, thank you. And after having the opportunity to review the affidavit, at this point, I'd just be reserving any argument for a former Arthur hearing downtown.
Okay.
Thank you.
All right, thank you. So are you Slater Narette?
Yes, ma'am.
Okay. So I'm looking at a probable cause charging affidavit that charges you with possession of MDMA. All right. The arrest warrant was previously signed off by a magistrate. Bond was set at $2,000. I'll reduce bond in the matter to the sum of $1,000. I will appoint the Office of the Public Defender to represent you. Special conditions of your release, sir, will be that you not be in possession of any substances that are not legally and validly prescribed to you by a physician. All right, thank you. Mr. Robbins?
Yes.
Mr. Robbins, I reviewed your probable cause charging affidavit that charges you with robbery with a deadly weapon and petty theft. Give me a moment. All right, I do find probable cause. I will appoint the Office of the Public Defender to represent you in the matter. I've also looked at an affidavit that charges you with driving while license suspended or revoked with prior knowledge. excuse me, I do find probable cause, sir. We'll appoint the Office of the Public Defender to represent you in each. As to the driving on a suspended license, bond will remain at $500. As to the robbery with a deadly weapon, what did I give the co-defendants in this matter? What did I give the co-defendant in this matter on count one? What bond, do you remember?
It was 7,500.
All right, so I'll set bond at $7,500 in count one. Count two will remain at $100. Special conditions of your release will be that you not be in possession of any weapons or any firearms, do not have any contact with your co-defendants Daniel Jernigan or Regina Battle, do not have any contact with the victim in this matter, and do not return to the scene of the offense. All right, thank you. And obviously not operate a motor vehicle without a valid driver's license. So we have Mr. Rodriguez.
Yes, ma'am.
Sir, I reviewed a probable cause charging affidavit that charges you with possession of synthetic narcotic within 1,000 feet of a college. Defense wish to be heard?
Yes, Your Honor, just as to probable cause, I don't think the affidavit on its face is sufficient for the court to determine that this substance was a controlled substance or that it's something that is actually illegal. Given the change in the law with hemp and CBD, I don't think that there's sufficient information for probable cause.
Well, he did do a field test on it, and it came back presumptively positive for synthetic cannabinoids. I understand what you're saying. But probable cause is such a low standard. I'm more concerned with within 1,000 feet of a college. I don't see anything in the affidavit that lets me know that it was within 1,000 feet of a college, unless I'm mistaken. State?
That's correct, Your Honor, and the address is provided, however, it doesn't state that it is within 1,000 feet.
I'm sorry, I couldn't hear you.
I'm sorry.
The printer was running, I can't hear you. Speak up.
I agree with the court. It doesn't actually state that it's within 1,000 feet of college, unless we could verify the address that was provided is within 1,000 feet of a college. I would ask for it to be reset to get more information from the officer.
I'll just find probable cause as to the possession of synthetic cannabinoid, and with regard to that, it would be a lesser included offense. So I'll find probable cause as to the lesser included offense and overrule your objection. I'll go ahead in this matter, though, and given all attendant facts and circumstances, I am going to release him on his own recognizance. So I'm going to do so with the understanding that you need to stay in close contact with the attorney that's assigned to you from the Office of the Public Defender. I've appointed them. Keep the court file as well as the attorney from the Office of the Public Defender apprised of all addresses that you have. you're listed as a transient, so the bottom line is, if we don't to have an address to get word to you about when your court date is of the state files and you fail to appear, that's on you, okay?
I always check the phone for the clerk of the court anyway when I got cases, so.
Well, there's public records, you can
Yeah.
access the clerk's website, you can check your case
Yeah.
daily. So there's really no reason in this day and age for not being apprised of your court dates. Now, I do not want you returning to the Cimarron address, 1201 North Cimarron. I don't know if there's a college around there, but if there is, I don't want you returning within 500 feet.
I don't think there was a
Of that
college around there either because I go to the methadone program there. So
Okay.
I didn't think there was a college around there next to that program.
All right, so if you have, if there is a methadone clinic that you do attend, I will allow you to be in that area for
Mhm.
that purpose and that purpose only, okay?
Okay.
All right.
Yep. All right, thank you.
You Jason Davies?
Yes, hello.
All right, sir, you're being detained with regard to an allegation of violation of conditional release, or, excuse me, conditions of pretrial release. State, maybe I'm missing it. What's the case number that he is out on PTR when this is alleged that he had contact with the victim? The no contact order? I just see reference OCSO case number 1966639. I don't see a court case number.
I think it's 2019 CF
10588.
10588. Yes, ma'am.
All right, that's my fault. There is an order of commitment underneath this PC affidavit that I did not look at. So there is in fact a no return, no contact order in that case where he was charged with battery by strangulation, false imprisonment. All right, sir, so I will find probable cause. I will provisionally appoint the Office of the Public Defender to represent you in the matter. You will continue to be held. Well, I'll listen as to bond. You want to have any argument as to bond on the matter?
Yes, Your Honor, I believe since this is now an M1 that he is entitled to a bond on the case. Unless there's something that I'm missing in the court file, but it looks like this has been just created as its own misdemeanor case, so he would be entitled to to a reasonable bond on that case. And then, of course, if the state in Judge White's division or Judge White wanted to pursue action as far as pretrial detention, that would be up to the trial division.
Well, I can find that he's violated his conditions of pretrial release in 2019 CF 10588. He's out on that case. The bond was $2,500 in count 1 and $150 in count 2. Based on what I'm reading in this probable cause charging affidavit, so that's in fact what I'm going to do, okay? Sir, as to that 2019 CF 10588 case number, I do find probable cause to believe that you violated the conditions of your pretrial release. I'm going to revoke your release status in that case, and you will be held without bond in that one. As to the violation of conditional release, I will set bond in the sum of $100 in that matter. You are to follow all court orders, which include no contact, obviously, with the named victim in the matter, and that includes while you're incarcerated. Thank you.
Your Honor, I would just like to say that I was in fact invited over,
It's
Okay.
and I understand that I wasn't supposed to.
would not advise
and I
talking
understand.
about the facts of the case. Not a good idea.
Sir, what your attorney's doing is she's telling you that you have a Fifth Amendment right to remain silent. Everything here is being recorded. So if you say anything about the facts of the case, if you
No,
say
it's not
anything
about the
that could be
facts.
even construed as being inculpatory, it could be used against you, all right? So for purposes of this hearing, I'll strike everything from the record that he said, and it cannot be used against him in the future. But do follow that advice carefully, okay? You might have defenses to it, but you want to go over that with the attorney that's assigned to you from the Office of the Public Defender too, all right? For the one today was $500. The violation of PTR.
This is my phone right now.
Yes.
Sir, your name?
Robert Malashevsky.
All right, sir. Looks like you were detained on a warrant that was issued for failure to appear. It was failure to appear for trial. And there is a bond of $200 that was set in that matter. Bond will remain as set. There is a new charge that you're also picked up on, and there is a probable cause charging affidavit that charges you with retail theft out of a Publix. All right, I do find probable cause. I will have bond remain in that matter in the sum of $2,500.
$2,500. What's that mean?
I'm sorry, $250. I apologize.
Oh, and
Hang on one second, please.
That's for the traffic case.
that's for traffic case. All right. Is there any way I could do time server and all of it? I have like 50 days built up that I shouldn't have been in jail. Can I do that right now? Okay, yeah, resolve that and this new case.
Your Honor, while the court's considering bond amount.
What I was considering doing was just revoking, setting his bond at 0 on the failure to appear as opposed to the 200 that the issuing judge set, because he was out in this case and got arrested on a new law offense. Yes.
I understand, Your Honor. He's interested in resolving both cases if possible, or at minimum, the traffic case where he failed to appear. Looks like it's an expired driver's license, more than
Yes.
6 months, which would, it's usually civil, but I guess it could be an M2. Looks like it's charged as an M2.
It would have to be for a warrant to be issued for his
Right.
arrest for failure to appear. It would have to be a criminal case.
Well, I just spent about 50 days in jail and got charged with nothing. So I was wondering if maybe I could get time served on those.
Well, I'm more concerned with the thefts out of Publix than I am with anything, sir. How many days has he been in?
Just now,
Just one day?
this is my second day, I believe. Or maybe I could get PTR for that.
I'd probably sentence you, it's not a lot, but if you want to enter a plea, I would sentence you to about 5 days on the retail theft.
Okay,
If that's something you want to consider, you can go over it with your attorney, and I'll take your pleas to both.
I'll take it now. Just 5 days.
Sign it. 5 days. Sign the plea form if you would.
And Your Honor, would that be as to the CT and the
I'll put
MM?
them both concurrent.
And yeah, so the driver's license thing is resolved.
Yeah, do both.
All right. I have court in Seminole County on the 4th, I believe. What do I do about that?
Well, if you're in jail, you're in jail. They'll be notified that you're in jail potentially. Potentially, they won't be. Usually what happens in this county is when attorneys are before me and I don't have someone that is in court, and they should be, I ask they check FindLink, which is a website that they can go to see if someone's incarcerated. I don't know if they do that in Seminole County or not.
They do that in Texas.
You might want to get word to Seminole County that you're incarcerated.
No, I don't have an attorney out there.
Now, I have, the only hiccup I have is with this
I just made
CT
bond
case.
out there though.
I can.
Is there gonna be any problem
right,
with
I just need
resolving the
extension
CT
there.
case here?
She's not, your question is why, because she doesn't have any
Okay.
authority over Senate. So,
Right. I'm just asking you because I'm not familiar with it.
see, I'm right your name, I'm trying to.
All right, sir, is this your signature?
If I can get it. Yes.
All right, and you want to give up all the rights on this plea form and enter pleas in each of these cases, sir?
Ma'am, yes.
All right, you entering pleas of guilty?
Yes.
All right, so in 2019 CT 4782, I will adjudicate you guilty, sentence you to time served. There is the imposition of some court costs in that matter. I am not going to reduce them to a civil judgment against you. I don't know what the court costs will be, do you know? All right, so I'll give you 6 months within which to pay them. If you don't pay them, it might result in the revocation of your privilege to drive, okay?
Okay.
In the other case, the petty theft case, 2019 MM 7257, I do adjudicate you guilty, sentence you to 5 days in jail, give you credit for 1 day in, and there are court costs in that case. And again, I'll give you the same period of time within which to pay those 6 months. All right, both cases will run concurrent with one another. Do you have any questions about the sentence?
No.
So you'll spend 5 days in here with credit for one, and then you can go on and do whatever you need to do in
Yes,
Seminole County.
if I get trustee service, or
I'm
trustee,
sorry?
if I get trustee status.
I don't know. I don't know how much more gain time or credit they'll give you. Okay?
No, thank you.
All right, thank you.
I don't need no public defender because I just got a trespass.
Are you
Nah,
Mr.
this-
Baswell?
My name Willie Pureford.
Baswell is mental health, Your Honor.
Okay. Mental health on Mr. Baswell.
And Kelvin Lee bonded out.
Who bonded out?
Kelvin Lee. Okay.
Okay. And I'm sorry, sir, you said your name was?
Willie Lee Pureford.
Okay.
And I just want to go back around there. I don't even know I went in jail for trespassing.
All right, so I've reviewed a probable cause charging affidavit that charges you with trespass on property after warning. I do find probable cause. Did you say that you wanted to enter a plea to it?
No content.
Okay. You want to go over that plea form, please, and then sign it after you've read it?
Yeah, I read that.
Yeah.
right, sir, I will accept your plea. I am going to go ahead and adjudicate you guilty of the offense of trespass after warning. I am going to sentence you to the time that you've served in jail, order court costs, reduce it to a civil judgment against you. However, you've indicated to me that you're not going to return, correct?
Never,
Never?
never.
Ever?
I'm going
Right.
back to Pensacola.
Okay. All right. All right, thank you, sir.
So I get out today?
You will.
Thank you.
You, Mr. Rodriguez?
Yes, ma'am.
Sir, I've reviewed a probable cause charging affidavit that charges you with giving false information to a law enforcement officer. I do find probable cause. I will appoint the Office of the Public Defender to represent you in the matter. Bond is set in the sum of $500. It will remain as set. Thank you, sir.
Yeah, that's all.
Jeremy Reynolds? Mr. Reynolds, you're being detained because you have 2 out-of-county warrants. It looks like they're out of Lake County, both of them. 2019 CF 2385. Well, wait a minute, this is the same case number, 2019 CF 2385. You have 1 warrant out of Lake County. The face sheet indicates that he's got a $5,000 bond on one and a $10,000 bond on the other. However, there's just 1 case number.
He has 2 counts today.
That's what it is?
Yes.
Okay. All right, so on count 1, then it is $5,000 bond. On count 2, it's $10,000 for a total of $15,000. All right, sir, you'll be transported to Lake County when they're able, okay? Sir, your name?
Mr. Adam Seeley.
All right. Mr. Seeley, you're being detained because you have an out-of-county warrant from Seminole County.
Yes,
Bond is set in the issuing magistrate set bond in the sums of $3,000.
Yes, ma'am.
PR, I'm looking at a face sheet. Is there any other action that you want me to be advised of?
He has that, detained for the out of bond, did you address that? For 2019 CL 0088868. For Orange.
I got a bond in the sum of $10,500 on it.
Yes, ma'am.
It's burglary of a conveyance ×2 and petty theft.
And I've actually kept my nose clean the whole entire time.
I'm sorry, I couldn't hear you.
Sorry, I've actually been good the whole entire time. I haven't been doing anything at all. That was, Seminole County was an old case.
Right.
Yes, ma'am.
All right, bond will remain as set. Okay,
Thank you, ma'am.
all right, thank you.
All right, you have a blessed day.
James Boyer is mental health, Your Honor.
Okay, Mr. Boyer, still mental health? Your name, sir?
Randall Sanko.
All right. Sir, the affidavit charges you with disorderly conduct in violation of City Ordinance 43.06. Does he wish to resolve it today?
I'm going to plead no contest.
Okay. They're going to give you a plea form, sir. I'm going to have you review that, sign off on it. After you have, I'll address you.
I mean, that's really what I'm looking at, hopefully, anyway.
Just want to make sure that you understand.
Yeah.
You're good with that. I don't know if.
All right, sir, did you sign that form?
Yes.
All right, and have you entered pleas of this nature before?
Pardon me?
Have you entered pleas of guilty?
Oh,
on these
yeah,
kinds
well,
of
no
things?
contest.
Okay, all right,
I'm
well, I'll
not gonna
accept your
fight
no.
it.
All right, I'll accept your no contest plea. I will adjudicate you guilty, sir, of the offense, sentence you to time served, reduce the court cost to a civil judgment against you.
Thank you.
Thank you. Ma'am, tell me your name.
Rachel Jenkins.
Ma'am, I'm looking at a probable cause charging, affidavit charging you with solicitation without a permit. I do find probable cause. If you want to enter a plea, ma'am, to it, I would just simply adjudicate you guilty, sentence you to time served, give you court costs, reduce those to a civil judgment. You want to discuss that with the attorney to your left for a moment?
That's fine.
Is that what you want to do?
Yes, ma'am.
All right, there's a plea form in front of you. You want to read that? Sign it if that's what you want to do.
Judge, were you appointing the PD or?
All right, ma'am, is that your signature on that form?
Yes, ma'am.
All right. You understand the rights that you're giving up when you enter a plea?
Yes, ma'am.
All right, so I am going to adjudicate you guilty of soliciting without a permit, sentence you to time served, and I will reduce the court cost to a civil judgment against you. Thank you, ma'am.
Excuse me?
Sir, tell me your name.
Hector Quinones, De Leon.
All right. Sir, I've reviewed a probable cause charging affidavit that just charges you with open container. I do find probable cause.
Yes.
It's up to you if you want to resolve it today. If you wanted to resolve it today, I would adjudicate you guilty of the offense, sentence you to time served, impose court costs in the matter. Are you employed?
Yes. I mean,
Is this part-time?
semi-employed, part-time.
Okay. All right, you feel like you can pay?
Preferably full-time, but that's, right now, we're part-time.
Okay, all right.
Maybe, and what is the court cost gonna be?
I don't know.
Okay. 'Cause it's just
This
like-
is, I can tell you this is a misdemeanor, so the court costs were gonna run you right around $300, okay?
Yes, ma'am, yes, ma'am.
Okay, I'll give you 6 months to pay it. Is that
Okay,
enough time to
fine.
pay it? You need longer to pay it?
I might need longer. I got more fines I have to pay also, so I'm gonna have to stack them all together. And
So you tell me, how long do you need?
I can't answer that right now, but I'm gonna need probably a bit longer.
How about a year?
That'll probably do it.
Would that be all right?
Yes, ma'am.
Okay. Review that form. I'll go ahead and reduce the civil judgment in this case. All right, sir, is this your signature on the form?
Yes, ma'am.
All right. And is that what you want to do, is enter a plea?
Yes.
You understand the rights you're giving up?
Yes, ma'am.
All right, so I will adjudicate you guilty of open container, sir. Sentence you to time served. I am going to reduce the court cost to a civil judgment against you. All right, and so
What does
with,
that mean?
you can explain it.
Okay, so they pay it back.
No.
Okay. Thank you. Have a nice weekend.
You too. Glenn Wright?
Yes, ma'am.
All right, Mr. Wright, I'm also reviewing an affidavit that charges you with open container. I do find probable cause. Like the last gentleman, if he wanted to take care of it by virtue of entering a plea, I would just simply adjudicate you guilty, sentence you to time served, and reduce the court cost to a civil judgment against you. If
Yes.
that's something you want to do, you certainly don't have to, but if that's something you want to do, there's a plea form in front of you. Please read it, execute it, and then I'll go from there. Is that what you want to do, sir? Enter a plea?
Yes, ma'am.
And you know it'll go on your record as an open container.
Yes, ma'am.
All right, you understand the rights that you're giving up by virtue of entering a plea?
Yes, ma'am.
All right, so I will adjudicate you guilty of the offense of open container, sentence you to time served, impose court costs, reduce those court costs to a civil judgment.
Yes, ma'am. Thank you.
Thank you, sir. All right, that's all we have, correct? All right, we're in recess until tomorrow.